finally, you know, so many of the problems that people are rightly pointing out in this discussion today, you know, they're problems that we face, you know, no matter what, no matter where we try these people. You know, Professor Kelley was speaking about the likelihood of zealous advocacy by the lawyers who are fortunate or unfortunate enough to be assigned to represent the 9/11 defendants. Well, I tell you, the tremendous professional military lawyers who served as defense counsel in the military commissions in Guantanamo, including Lieutenant Commander Charlie Swift, who represented Hamdan up successfully to the U.S. Supreme Court. In my judgment, as a practicing lawyer and as a defense lawyer, those lawyers are second to none in terms of the zealousness and the effectiveness that they brought to the defense of their clients in what I think all would agree was a flawed military commission system in prior years. So why do I make that point other than to, you know, give them a shout out? It shows that, again, this problem of like zealous defense counsel is not going to magically disappear if you transfer people to the military commission system. If we're serious about trying people, and we should be, of course they should have zealous counsel. Of course they should have a fair hearing. It's the same Constitution. The Constitution doesn't go away when we have military justice. In fact, one of the other, to me, inspiring things that's happened in the years that we've been having this national debate is the tremendous role that members of our Judge Advocate General's Corps, retired members, have played in criticizing efforts to short-circuit the military justice system. The military justice system is not a second-class justice system, and it shouldn't be viewed that way. A lot of these same problems will be there if all these defendants are tried in military commissions. Plus, as Professor Flaherty points out, you're in a brand new system that's been tinkered with and amended and changed. You've got a brand new statute, and by definition, you don't have the body of precedent and experience. You don't have the reservoir of defense counsel and judges and prosecutors who know the way around these issues. So you're starting off, even though it might seem like, oh, just put it all in the military's lap and it'll be an easier problem. The experience in Guantanamo with the prior military commission shows it ain't easy. And those proceedings, I think, were widely viewed as a disaster, including by many people who are very hawkish in this area, the verdict in the Hamdan case, where he, although he was convicted on a minor charge, effectively got time served. So the problems don't go away by saying, let's send them to military commissions. These people, in my judgment, need to be prosecuted, they need to be convicted, they need to be punished. The world needs to understand that we're treating them fairly, and we're not compromising, but we are holding them accountable for what they did. And my judgment is, based on the experience that we've had, the best way to do that is to prosecute them in the system that we know, and based on our experience, have good reason to believe will be capable of getting that job done.
I'd like to open up to questions from the audience.
You talked about ruining the lives of the judges. What about the lives of the jurors? How would they be protected? Would it be necessary to sequester them for the length of the trial?
What's that?
So clearly being picked on the jury for this case would kind of not be most people's idea of fun. And I think Professor Kelley pointed out jury selection in any of these cases is a very challenging task. But we've had lengthy, difficult criminal cases, and we have them all the time, gang cases, organized crime cases, and the other terrorism cases. And, you know, we'd have virtually certain an anonymous jury in this case, which means that the jurors' identities are not known, and they are subject to the protections that the Marshal Service provides. They oftentimes, they meet at a location away from the courthouse, they're brought down to court together. And, you know, during the voir dire process, for jurors who feel like they can't cope with that, and probably many people would say, I don't want to be a part of that. You know, most judges, I think, would say, okay, then you can't be fair and you're not going to be on the jury.
What about the sequestration?
That's pretty unusual in federal court. That almost never happens in federal court.
Just a quick related point on juries. You've spoken about classified information going to the defendants. What about the jurors? Are you going to run background checks on all of them, give them security clearances, give them the burden of that? One of the techniques sometimes attempted to be used is the jury is given access to information that the defense and the defendant are not. Whether that's going to stand up in the long run, Lord knows.
Somewhat of a political question. This is for Professor Kelley. As a former deputy counsel in the White House, I'm sure you know the role of politics often comes into the discussion between the executive and the staff. You made a very persuasive list of issues with trying someone like this at the level at the federal court. My question is, does the president right now has obviously had a very similar conversation with his counsel and their deputy counsels and the Attorney General and his senior staff. So, if you think that they might lose, can it possibly be true that the deputy counsels there fundamentally disagree with you or agree with you but would risk at all possibly losing? I mean, when I heard this decision, my thought was they must have done this rigorous analysis, and they must be pretty sure that they can win. And I just think a suggestion otherwise would be politically disastrous for them.
It's a good question. Of course, extremely able lawyers have spent huge amounts of time and effort analyzing whether they can get convictions in these cases, dealing with all of the issues that they anticipate arising, and they would anticipate all that they could think of, and they reached a sober judgment that they could and that they would. It was highly likely. It's very hard for me to believe that this could have gone forward had they not concluded that. Having said that, it's a predictive judgment, and I have to say, I think the Attorney General has it's my impression at least, the Attorney General has a very strong policy view about trying these people in civilian court if it's at all possible to do it. As Professor Flaherty says, he must have viewed the burden on those who would say, let's do something other than civilian court prosecutions. So I'm not sure what the internal debate and analysis was. I hope and expect that much of the work was done by career prosecutors who are hard-nosed and realistic in their appraisals of these kinds of matters. I don't know, what the documents say in terms of how they're going to deal with all of these problems. I'm sure that they are quite worried about all of the procedural challenges that they're going to face. I think these defendants will be convicted because, well, first of all, they're guilty. Second, I'm sure the government has lots of evidence. I've seen myself lots and lots and lots and lots of evidence against some of these folks. I don't know how they drew the lines between what they viewed as admissible or not. That is an uncertain thing for them to predict. And I also have to say, I don't think these defendants can get a fair trial, period. I just don't. Because of the notoriety, et cetera, I think that it will be in many ways either a complete disaster or a show trial, either of which I find very attractive.
For the next question, I'll just throw a little factual tidbit into the mix. My understanding is that all of these defendants were ready to plead guilty before the military commission, and then the charges were withdrawn. So I don't know if it goes to question why bother.